Mr. Driscoll, you've been very patient. I hope it at least was an educational morning for you.
It's always interesting to sit in on these earlier cases because you always learn something. It never ceases. In all my years, though, this is the latest I've ever been up here in this appellate court. I am Jim Dressler. I represent the father who was the petitioner in the lower court. This is an appeal from an order of the trial court denying the father's supplemental petition to change custody of the party's minor son, Samuel Robert, who was born February the 16th, 1998. Samuel was 8 years old at the time of trial. The standard review in this action is abuse of discretion. And this is an intensely fact-driven case. Unfortunately, I have searched the law in the state of Florida, and I have never run across a case where a trial judge has allowed a minor child to reside in the same home with a convicted sex offender. There may be cases, but none are in the appellate records.
Well, just for clarity's sake, am I correct that her ruling said that the convicted sex offender could not reside in the same home, although I recognize he's living next door, or he's living pretty darn close?
Well, essentially, if you look at the facts as the judge found them, there's a complete anomaly there. On one hand, she says that the mother has provided a safe environment for the child. Then she finds, essentially, and these are the interesting facts, because she goes on to find that the former wife tends to minimize the severity of the facts and circumstances of her husband's conviction, has no concerns about her present husband being around Samuel, and does not believe that her present husband has done anything wrong. So then what does she do? She says, I fail to find that there has been a substantial change of circumstances that would justify a change of custody in the best interest and general welfare of the child, however. And that however is a big however, because essentially what she says is, and it's very interesting, the former wife shall not allow the minor child to reside in the same household with Mr. Langston, and at no time shall Mr. Langston be in the minor child's presence without constant and direct supervision. At no time shall the minor child be alone in the presence of Mr. Langston. Now, essentially what she's doing is putting the fox in charge of the hen house. She's already found that the wife, the mother, doesn't believe that Mr. Langston has done anything wrong, yet she's saying because she found that under Alabama law that Mr. Langston may not live. But that's not what the Alabama law says. Essentially, we produced at the time of trial certified copies of 3 opinions of the Attorney General, and he sets forth in the Community Reporting Act, which is in the Code of Alabama, that no criminal sex offender shall establish a residence or any other living accommodation where a minor resides. Now, the wife testified that she wasn't about to divorce her husband, and essentially they lived together. He was in the same household until it came time for Samuel to go to bed. Samuel would go to bed, and then Mr. Langston allegedly would walk down the street and sleep at his residence and supposedly be present in the household the next morning when little Samuel woke up. Now, I suggest that under the circumstances, if you look at all her findings, and those findings are adequately set forth by the court in her final judgment, and I find it to be an anomaly when she makes these findings and then says on the face of it, they don't establish a substantial change of circumstance. Essentially what she says is, and she outlines when the parties were married, the fact that they got divorced, the fact that there was a marital settlement agreement agreeing that they would share parental responsibility for the minor child, and the fact that the mother had relocated to Alabama at that time and would live there. Then she goes on to find that in 2004, former wife got married to Mr. Simmons. That was her third marriage, the court said, and that lasted only 2 months. The mother then moved the child from his school over to Hartsville, Alabama, and when that marriage fell apart, she moves him back. Court found that the child had lived in 6 different locations since the parties were divorced, and that the child had been in 3 schools. The essential element here is not only did the mother not exhibit any stability for this minor child, but essentially why we're here is because the mother placed her own romantic interest above the best interest and general welfare of the child. Now, essentially, when we come in and seek to change custody, we have to show that there's been a substantial change in circumstances before we even get to the question of whether or not it's in the best interest and general welfare of the child to change custody. Now, in the Wade versus Hirschman case, our Supreme Court said that some of our appellate districts have allowed a third element to creep into the law, and we find that third element is improper. That third element is that to allow the child to remain with the residential parent would be detrimental to the best interest and general welfare of the child. Now here, after all these findings, and the fact that the mother really is not concerned about the father, and the fact we introduced a document that was a certified copy of the sentencing agreement on the husband that occurred right before the trial, the husband was charged with a violation of the Community Reporting Act because he was a convicted sex offender. He was employed at a location within 1,000 feet of a school or daycare facility, which is a felony in the state of Alabama under their law. And it's set forth in that. He was sentenced to 10 years in prison under that felony. That sentence was suspended and he was given 3 years probation.
So, Justice, is it your position that the trial court is prohibited from granting custody to a person who is married to an individual who has been designated a sexual offender?
I would suggest that would be excellent law, and I don't know of any court, in my opinion, that would grant custody of a minor child to any person that was living openly with a convicted sex offender in the state of Florida. That's why I haven't been able to find any cases, in my opinion. I don't know if there are any cases in the state of Florida. If there are, they certainly haven't been reported.
So with that, taking that position would be irrelevant, for instance, if the sex offender had committed an improper act on a 16-year-old girl and there was a 17-year-old boy living in the house.
Your Honor, I don't know that that really makes a difference. A sex offender is a sex offender. We have certain laws in the state of Florida regarding them as well. And under the circumstances here, the poll star in the state of Florida in all custody situations has always been, what is the best interest and general welfare of the child? It's not necessarily whether or not the mother has provided a safe place or the father has. Here, the court found that the child was closely bonded to both of these parties. But this is not a father who abandoned his child. He exercised all the visitation plus more than he was granted in the state of Alabama and in the state of Florida. The record shows that he had remarried and he had the same home that the child was born in because he purchased the former wife's interest in that. And under the circumstances, I understand that that in and of itself wouldn't justify a change of custody. But again, how can we say that it's in the best interest of this child to allow him to remain in the home where a convicted sex offender is there except during the time that that sex offender goes to bed? Now,
Well, the trial court seems to be saying that there's no evidence of any risk to the child.
that's like saying, well, you know, nothing's happened yet, but the court evidently was under the impression that she had to do something to protect the best interest and general welfare of the child. Why would she tell a woman married to a man that, look, you can't live with your husband while the child is in the same house? Now, once the court rules that, who's going to monitor that? How do we know if Mr. Langston is in the same house or not? And under the circumstances, she said that you will never leave this child alone with Mr. Langston without constant adult supervision. So it's clear, in my opinion, that this trial judge understood that it wasn't appropriate for this child to be in the presence of this individual in any kind of a living arrangement or unsupervised. Because why would she impose those restrictions if there hadn't been a substantial change? And why are those restrictions imposed if, in fact, the mother is providing a safe place for the child, as she found? As I say,
Wasn't her order essentially requiring the mother and the stepdad to comply with Alabama law?
Well, it's
Florida doesn't have a provision like that, but Alabama has a specific statute, and doesn't the trial court's order essentially incorporate that statute and say comply with it?
I believe that essentially that the trial court did that because she found, and specifically found, based on what we presented to the court, that Alabama law made it a felony for an adult convicted child offender to have any living arrangement wherein the child resides. And under the circumstances, if in fact that is the case, why would the court allow a child to remain in that environment if she's going to uphold the Alabama law? But apart from that, I would suggest that, and I've practiced law a long number of years, and I don't know of any judge, any trial judge, that would allow a child to remain in the same home with a convicted sex offender because it's a disaster waiting to happen. And that's the circumstance. Here the trial judge is trying to avoid that disaster. But again, she puts the mother in charge of enforcing those provisions. She doesn't say that there's got to be some independent investigation done by anyone. And here, and I recognize that the mother called this investigator from the Children Protective Agency in the state of Alabama, and he said, well, nothing's happened yet. And I asked him, well, did he consider the Alabama law? His answer was, that's up to the Attorney General. In other words, we don't care about what the law is there. Unless something happens, we're not going to do anything about it. State agencies should act together. That's a good illustration of the fact that sometimes this agency doesn't cooperate with another agency. But I suggest that if you look at this trial judge's findings, and then if you look at her ruling, the ruling doesn't comport with the findings. And it's our impression, essentially, that we had substantial evidence in this record, and the court made findings that would justify a substantial change. Otherwise, why did she amend the final judgment? That's what she did. And again, she's saying it's in the best interest and general welfare of this child that I've got to protect him, even though I allow him to stay in this environment. Now, theoretically, perhaps maybe she did do that because of the Alabama law, but hopefully she also did it because she was concerned about the best interest and general welfare of this child. In other words, absent that Alabama law, would this trial judge have said, well, because he is a convicted sex offender and he's openly lived there and the mother allowed him to openly live there until the father filed this action, perhaps I need to do something to protect this child. And I suggest that it's not in the best interest in general welfare to allow a child to remain in an environment where the trial judge found that she had to do something to protect the best interest in general welfare of the child. We're then asking this court, in essence, to reverse and remand and direct the trial judge to change custody because, based on the fact circumstances and the facts that the court found, it doesn't justify allowing the child to continue to remain in that environment, and it's not in that child's best interest to have him grow up in an environment where the husband can't even sleep in the same house where he sleeps, and the husband can't even be left alone for a moment. He can't take the child to an amusement park. He can't take them to a movie. But again, my big problem here is who monitors that? And again, I say the trial judge essentially put Ms. Langston in charge of monitoring that provision, and Ms. Langston has already said, I don't think my husband has done anything wrong, and I'm not concerned about him being around my child.
Thank you.